As a market leader for all conveyancing and notarial-based matters, we would like to take you through the transfer process and show you how we can make your dream property a reality. For the majority of South Africa, the transferring attorney is elected by the seller, who is then mandated to transfer the property into the name of the purchaser. It is important to note that in most transfers, there are 2 or more attorneys involved in the transfer process. The transferring attorney, the bond registration attorney appointed by the purchaser's bank to attend to the registration of their new mortgage bond, the bond cancellation attorney appointed by the seller's bank to ensure that the seller's existing bond is settled and cancelled at the deeds office. Overlap between these attorneys are possible but not common. The transfer process can be roughly summarized in 7 steps. Step number 1, the receipt of the offer to purchase by the transferring attorney. The transfer process commences with the transferring attorney receiving the signed and accepted offer to purchase from the seller or from the estate agent's office. In our example, NR Nagel attorneys will step into the shoes of the transferring attorney. Once we have received the offer to purchase, we will then proceed to open our file and send our initial letters to the seller, purchaser, and estate agent. In these letters, we request the required FICA and other documentation that will be essential during the transfer process. We further administer the agreement between the seller and purchaser to ensure that all the conditions of the offer to purchase is timeously adhered to. Once we have received all the required documentation from the parties, we will proceed to request bond cancellation figures from the seller's bank, which will act as the seller's notice to cancel his bond and limiting the early termination penalty levied by the bank. Step 2, the fulfillment of suspensive conditions. Most offers to purchase is subject to 1 or more suspensive conditions that must be adhered to before a valid and binding agreement of sale will come into force. A common example of a suspensive condition is that the purchaser must obtain bond approval for a specific amount on or before a specified date. Upon fulfillment of such a suspensive condition, the formal transfer will commence and the bond attorneys will be appointed by the purchaser's bank. Step 3, drafting and signing of documents. Once the suspensive conditions of the offer to purchase have been met, both our office and the bond registration attorneys will proceed in drafting their registration documents and arrange signature thereof by all parties. During this stage, we will request guarantees to secure the purchase price from the bond attorneys, rates clearance figures from the municipal council, and if the property is situated within an estate or sectional title complex, levy clearance figures from the homeowners association or body corporate. Step 4, performance by the purchasers and sellers. After the documents have been signed, both the seller and purchaser is obliged to perform their respective obligations to ensure that all the required documents and certificates is obtained by our office to proceed with lodging the documents for registration at the deeds office. The following documents and certificates are required for lodgement purposes. Guarantees securing the purchase price. The bond registration attorney will be able to issue the required guarantees upon signature of the bond registration documents by the purchaser. Guarantees are an irrevocable promise given by the bank that the seller's existing bond will be settled and the remainder of the purchase price will be paid to our trust account. Attorney registration fee. The purchasers will attend to the payment of the transfer and bond registration fees to the relevant attorneys. Upon receipt of the transfer fees, our office will be able to pay the transfer duty to SARS. Transfer duty is a tax levied on the purchase price of the property acquired by the purchaser and is calculated using the transfer duty scale published by the South African Revenue Service. SARS will issue the transfer duty receipt upon payment of the amount due. In some instances, the property transfer is exempted from transfer duty, and in such an event, a transfer duty exemption certificate will be issued by SARS. This receipt or exemption certificate is required for lodgement at the deeds office. Before transfer of the property is effected, the seller is required to attend to the payment of the rates clearance figures containing all arrear municipal accounts together with 4 months rates and taxes in advance, before the rates clearance certificate will be issued by the City Council. This certificate certifies that all municipal accounts for the preceding 2 years until the date of registration is paid in full by the seller and is required for lodgement purposes. Levy clearance certificate. The same principle as with the municipal accounts applies for the levies of a body corporate for a sectional title scheme or homeowners association. The levy clearance certificate certifies that all arrear levies together with levies paid up to date of registration has been paid by the seller and this certificate is also required for lodgment at the deeds office. It should be noted that with both rates and levy clearance payments, the seller will be refunded any amounts overpaid to the respective authorities after registration of transfer is effected. Compliance certificates. The seller is obliged to provide compliance certificates for the electrical, gas and electric fence installations, certifying that these installations are safe, in working order and installed in accordance with the prescribed regulations. The compliance certificates will be delivered to the purchaser after registration of transfer has been completed. Step 5. Lodgment in the deeds office. Once all the documents required for lodgment have been prepared by the various attorneys, our office will liaise with the bond registration and bond cancellation attorneys to arrange simultaneous lodgment of the registration documents at the deeds office. After the registration documents are lodged at the deeds office, the documents will follow an examination process consisting of 3 levels, which will take approximately 7 to 10 business days. Step 6. Registration of transfer. Once all 3 levels of examination have been completed and the documents are deemed correct by the deeds office, the documentation will be sent for deeds preparation to be prepared for registration by the Registrar of Deeds. During this period, all the attorneys involved with the transfer of the property will ensure that their financial position is fully guaranteed and that the transaction is ready for registration. The attorneys will then confirm that the matter may be put forward for registration on the following day. Step 7. Finalization of payment. Upon confirmation of registration of transfer by the Registrar of Deeds, the purchaser's bank will release the payment of the guarantees, enabling us to finalize the financials for the transaction and to attend to the final payments to the seller, purchaser and estate agent. At NR Nagel Attorneys, we are driven to complete all these steps in record time to ensure service excellence every step of the way. NR Nagel Attorneys, professionals dedicated to excellence.